Whistleblowers are individuals who disclose evidence of misconduct that threatens the public interest. Often these reports are made to Congress. The following discussion explores how to safely vet whistleblower disclosures.
My office received allegations from an individual who identified as a whistleblower. How can I safely verify that the information they are providing is accurate and reliable?
Evaluating a whistleblower's allegation is essential before relying on the information, because your office's credibility may be at stake. To mitigate risks, it's important to proceed cautiously and strategize with the individual on how to safely verify their allegations.
My office cannot investigate all the allegations we receive. Are there initial actions I can take to help ensure the individual is better off for having contacted my office?
Yes, there are a few ways you can provide support early in the process. First, give the whistleblower the benefit of the doubt when they come forward. Determining credibility is important if you want to use their information for oversight, but that can take time. You don't have to vet their allegations before providing some initial guidance like survival tips, non-governmental and governmental referral options, and the relevant whistleblower laws. That level of information can help them make an informed decision about how to safely move forward.
They are available on our Resources for Whistleblowers page, or you can contact our office for tailored guidance that can be shared with the whistleblower.
I'm glad we can at minimum play a guiding role. If my office does want to look into the allegations, can you elaborate on the potential risk you mentioned earlier?
Even when the whistleblower is acting lawfully, by sharing information, they risk exposing their identity and triggering retaliation. For your office, there is the risk that a misstep will cause unintended harm to a constituent or derail an important oversight opportunity.
I don't know where to start in this process. How do I begin to strategize with the whistleblower?
First, ask if they're represented by an attorney. An experienced whistleblower lawyer should be willing to share their assessment of the issues. They can also help the whistleblower navigate the challenging road ahead and assist in coordinating efforts with your office. If they don't have an attorney, we have a menu of nonprofit whistleblower support organizations and legal resources that you can share as a helpful starting point.
Next, establish ground rules. Discuss their desired level of confidentiality and if there are any limitations around your office's use of the information they provide. This will inform additional precautions you may need to take throughout the vetting process. For instance, if they want to remain confidential, then it is important to work together to screen out any key details that could identify them from your office's follow-up, and obtain their consent before sharing their information outside of your office.
Okay, that makes sense. Can I request specific evidence from the whistleblower to confirm their allegations?
It's actually best not to request direct evidence until you and the whistleblower have a plan in place. There may also be other ways for you to safely verify the allegations without their direct evidence, which we can discuss further.
Okay, but what if the whistleblower wants to provide documents? Is there any information that my office should not accept?
Providing classified documents through unauthorized channels and to unauthorized recipients could result in criminal prosecution. Only individuals with appropriate clearances can lawfully receive classified information. You can consult the House Office of Security and our office for further guidance.
And even when the whistleblower is sharing unclassified evidence, they could still experience civil or criminal liability. So, for example, an employer may claim theft of their documents. By association, you could then get swept into a legal proceeding, such as being a witness in a retaliatory lawsuit.
It is advisable for you and the whistleblower to consult your respective counsel before sharing or receiving documentation restricted from release. For more on handling restricted information, review our guide, Congress's Obligations when Working with Whistleblowers. But even when there are no restrictions, as a best practice, you should both use encrypted communications or meet in a secure location.
This sounds like a lot of work. I have a limited bandwidth. How do I get the key facts within a reasonable time frame?
Be upfront with a whistleblower about your limitations to help manage their expectations. And practice active, structured listening. That means putting together guiding questions in advance and summarizing what the whistleblower has shared to make sure your records are accurate. Check out our guiding phrases document for key disclaimers and questions you can use.
Once you have a clear understanding of the underlying disclosure, and to the extent it may be a priority for your office, give the whistleblower assignments to facilitate the vetting process. For example, ask them to provide a concise timeline of key events, written summaries of key evidence and a roadmap for document requests, a list of colleagues willing to corroborate their disclosures, or a summary of related disclosures made to other offices, including the status and investigative reports for review. This may include whistleblower agencies or offices of inspectors general.
For more in-depth strategies, check out our guide called How to Partner with Whistleblowers on Oversight.
What if the whistleblower struggles with the assignments?
The individual's willingness to roll up their sleeves during the vetting process is a useful approach to screening for viable partnerships. But keep in mind that if they struggle with these tasks, it does not necessarily mean their disclosure lacks veracity. Many whistleblowers have been traumatized by psychological and even physical retaliation, and it may be difficult for them to open up or provide a chronological account of events.
Earned trust takes time and effort. It helps to reiterate your office's confidentiality policy and to share our survival tips document. That provides a framework for the whistleblower to take precautions on their end. So for example, it shares best practices like engaging in whistleblowing on their own time and with their own resources, gathering evidence before drawing suspicion from their employer, and practicing self-care to help mitigate the emotional toll of retaliation.
Those are helpful tips for the whistleblower. But is it okay for my office to inquire with the employer directly about the allegations?
Remember to obtain the whistleblower's consent before communicating their disclosure with their employer or any third party. If they want to remain confidential, remember that often a whistleblower's information is highly specific in nature or known to such a small circle that their facts alone are their signature. If you contact their employer about the allegations, first work with the whistleblower to repackage their information so that it captures the underlying allegations while camouflaging them as the source. If that's not possible, decide together how to proceed.
We've developed a template whistleblower confidentiality policy and a consent form to help you safely handle whistleblower information and comply with House confidentiality requirements. For instance, under the Code of Conduct, House offices are generally prohibited from publicly identifying a whistleblower without their advance written permission.
This was an overview of key strategies for assessing disclosures. However, we realize that working with whistleblowers can be complex, and our office provides confidential consultations to assist House offices. You can also check out our Working with Whistleblowers Learning Hub, available in the Congressional Staff Academy, and access our guides and our templates on HouseNet. We look forward to serving you.